How did early court cases establish employee privacy rights? Imagine working in an office and wondering if your boss can look through your desk or check your emails without your permission. Early court cases helped answer questions like this. They set the rules for what kind of privacy employees can expect at work. These cases showed that workers do have some rights to privacy, especially in their personal spaces like offices and desks. Even when working for the government, courts recognized that employees have a right to privacy from unreasonable searches. One important case was O'Connor versus Ortega in 1987. The Supreme Court decided that public employees still have protections against unreasonable searches under the Fourth Amendment. They said that employees can have a reasonable expectation of privacy in their offices and desks, but this right can be limited if the employer has a good reason. For example, if a supervisor searches an employee's desk because they suspect misconduct, it might be okay. But if the search is for no good reason, it could violate privacy rights. Another case was Mancusi versus DeForte. It involved employees sharing an office and challenged a warrantless search. The court agreed that workers have a right to challenge searches that invade their privacy without proper cause. This case helped reinforce that workplace privacy is protected under the Fourth Amendment, which guards against unreasonable searches and seizures. Later cases looked at electronic data and computer use. Courts debated whether employees have privacy rights when using work computers and emails. Some courts said employees have a reasonable expectation of privacy in their work computers, especially if the employer has not clearly stated otherwise. Other courts allowed employers to monitor and access computers if they have a suspicion of wrongdoing. Courts also considered employee records. They recognized that employers need to keep some information private but also have a duty to protect sensitive data like medical or financial records. Courts often required employers to take steps to keep this information confidential. From these early decisions, it became clear that employee privacy rights are not absolute. They depend on the situation and the employer's needs. Employers should have clear policies about searches and monitoring, and employees should know what is expected. For example, workplaces should tell employees if their emails or internet use are being watched. In summary, these court cases helped establish that employees do have privacy rights at work. But those rights can be limited when the employer has a legitimate reason. These rulings continue to influence how workplace privacy is protected today.